Welcome back to the Deep Dive. Today we are getting into a case that, honestly, it feels less like one single event and more like, well, like a whole sprawling saga.
Yeah.
It played out over, what, 2 decades? In the courts, in the media.
Yeah, it's a beast. We're talking about Michael Peterson, the novelist, community figure, who then became an accused murderer, then a convicted one.
And then through this incredible collapse of the state's evidence, a free man. But not through acquittal, through something very specific.
That's right. And that whole arc, that's what we really need to trace today. Our mission here is to give you a kind of roadmap for this whole legal roller coaster.
Yeah.
How Peterson was convicted for his wife Kathleen's murder back in 2003. How that verdict just completely fell apart years later because of, frankly, huge forensic misconduct.
Right.
And then how it all finally wrapped up in 2017 with an Alford plea. It's not just about whodunit, it's really about digging into the power of forensic evidence, but also, crucially, how shaky a conviction can be when it hinges on that evidence.
So let's get the basics down first, a quick snapshot. The defendant, Michael Ivor Peterson. Novelist, columnist, let's say, controversial military claims we'll get into. The victim, his wife, Kathleen Peterson, very successful executive at Nortel.
Big job.
Yeah. And the date of death, December 9th, 2001, at their home in Durham, North Carolina.
And the outcome, it's like two different stories, isn't it? First, guilty verdict, life in prison 2003.
Right.
Then, boom, new trial, granted 2011. And finally, case closed with that Alford plea to voluntary manslaughter in 2017.
It's dizzying, like you said.
Yeah.
So to understand how a jury gets to guilty and then how that falls apart, we need to start at the beginning with Michael Peterson himself, because his whole story, his credibility, that was front and center from day one.
Exactly. Who was this guy?
Okay, so let's unpack Michael Peterson. He wasn't just some random person in Durham. He'd got a Duke, political science degree, even edited the student paper, The Chronicle.
Right, so known in the community, intelligent, connected.
But then there's the military service thing, and this became a huge deal at the trial. He served in the Marines, honorably discharged as captain in '71, after a car accident gave him a permanent disability. That part's clear.
Okay.
But when he ran for mayor of Durham in 1999, his story got, well, bigger.
Here we go.
He started claiming this really heroic record.
Yeah.
Said he'd won a Silver Star, a Bronze Star with Valor, 2 Purple Hearts.
Wow, okay, that's significant.
But the prosecution jumped all over this because the documentation just wasn't there. And they used it to paint him as someone who bends the truth.
And it wasn't just the prosecution saying it. Peterson himself eventually had to walk some of it back, didn't he?
He did. He admitted the injury for 1 Purple Heart wasn't from combat shrapnel in Vietnam, like he'd implied.
Yeah.
It was from a car accident in Japan after the war.
Okay, that's a big difference.
And then records contradicted the claim of 2 Purple Hearts altogether. For the jury, you can see how damaging this was. The prosecution basically said, look, if he lies about something like this, about heroism, couldn't he lie about finding his wife at the bottom of the stairs?
Yeah, it undermines everything. It plants that seed of doubt about his basic honesty.
And he also had this writing career, 3 novels about Vietnam. So he had this kind of professional authority on this subject, even with the embellished personal stuff.
Right, and this ties into his family life, which was, well, it was complicated. A blended family.
He had 2 sons, Clayton and Todd, from his first marriage to Patricia. Then, and this is crucial, back in 1985, he and Patricia became guardians to Margaret and Martha Ratliff. Their mother, Elizabeth Ratliff, had died over in Germany.
And we absolutely have to bookmark that name, Elizabeth Ratliff, because her death casts this huge shadow later on.
Definitely. So fast forward, he marries Kathleen Atwater, the Nortel exec, in 1997. She had a daughter, Caitlin. So altogether, it's this big family, 5 kids.
Which makes the night of December 9, 2001 even more tragic.
So what happened? The 911 call comes in around 2:40 a.m. It's Peterson. He says he just came inside, found Kathleen unconscious at the bottom of the staircase, like 15, 20 stairs.
And he immediately offers a possible reason.
Yeah, he suggests maybe she fell, said she'd had some alcohol, maybe taken some Valium.
So the fall theory is there from the very first call. What about the toxicology? Did it back that up?
Well, kinda, but not really strongly. Her blood alcohol was 0.07%.
Just under the driving limit in most places.
Right. And she had Valium, maybe 5 to 15 milligrams. It's considered subtoxic. It might make you a bit unsteady, sure, but enough to cause a fatal fall downstairs. The experts were skeptical.
But the real problem for Peterson, the thing that blew the accident theory out of the water for the prosecution, was the autopsy. Dr. Deborah Radish, the medical examiner.
Her findings were explosive. She concluded it wasn't an accident, it was a homicidal assault.
Okay, based on what specifically?
Two main things. First, this really specific injury, a fracture of the superior cornu of the left thyroid cartilage. It's like a little horn on your voice box.
Whoa, hang on. That specific bone, that's deep inside, isn't it? Protected.
Exactly.
Forensic experts usually associate that kind of fracture with really severe direct trauma to the neck or often manual strangulation. You just don't typically see that from a simple fall downstairs.
So the prosecution could argue, see, there was a struggle.
Right. And what was the second finding?
This was the visually shocking part. 7 deep lacerations. Cuts. On the top and back of Kathleen's head.
7, not one impact from a fall. 7 separate wounds.
Right, suggesting repeated blows. Something blunt. Radish estimated she died from blood loss maybe 90 minutes to 2 hours after getting those injuries.
Okay, that sounds damning. But the defense didn't just roll over. They brought in their own big gun, right? Dr. Henry Lee?
They did, the famous Dr. Lee. And he attacked the prosecution's core argument about the scene itself. He looked at the blood spatter.
What was his take?
He argued, pretty forcefully, that the patterns weren't consistent with a savage beating, the high-velocity spray you might expect. He said it wasn't there.
So what did he think caused the spatter then?
He testified it looked more consistent with an accidental fall where maybe she coughed up blood or expelled it somehow as she lay there injured. Lower velocity stuff.
Okay, so a direct clash of forensic interpretations right there.
Absolutely. And the defense hammered another point. If she was hit repeatedly with enough force to cause 7 deep cuts, why wasn't there more underlying damage?
Right. Where were the skull fractures, the major brain bruising, the swelling you'd expect from that kind of assault?
Exactly. So the defense argued the injuries just didn't fit the prosecution's theory of a brutal beating. It was this huge tension. Homicidal assault versus tragic accident with very weird injuries. That was the battleground for the 2003 trial.
So the trial kicks off July 2003, Judge Orlando Hudson presiding. The prosecution, led by James Hardin Jr., they knew they had this fight over the blood evidence. So they needed something else, right? They needed a motive, a why.
And they got a boost early on because the family dynamic shifted dramatically.
How so?
Kathleen's daughter, Caitlin, and her sister, Candace Zamperini. Initially, they supported Michael, stood by him. But then they learned about his bisexuality. And they read the autopsy report, those 7 lacerations. That changed everything for them. They withdrew their support and sided with the prosecution against him.
Wow, that's huge. Losing the support of the victim's own daughter and sister, that sends a powerful message to the jury.
Definitely. And it opened the door for the prosecution's main motive theory, the unhappy marriage narrative.
Right. This was driven hard by Assistant DA Frida Black, wasn't it? Very emotional appeals.
Very. She argued that Kathleen must have just found out about Michael being bisexual, about him having affairs with men he met online, and that she would have been, quote, infuriated and humiliated.
So the theory was, she confronts him, it turns violent, he kills her.
That was a core argument. They also threw in a secondary motive, a $1.5 million life insurance policy.
Okay, standard stuff for motive. But how did the defense counter this? I mean, didn't they have witnesses saying the marriage was fine, that Kathleen knew about his sexuality?
I did. The other kids, friends, they testified that Kathleen knew, she accepted it, the marriage was generally happy.
So how did the jury land on the side of the prosecution's motive? Post-trial interviews shed some light.
Yeah, some jurors later indicated it wasn't necessarily about whether the marriage was always unhappy. It was more about Michael's proven history of deception. Remember, the military medals.
Right, his credibility problem.
They felt maybe Kathleen had just found out about something new or something more serious. The shock of discovery could have triggered the argument. The prosecution basically leveraged his untrustworthiness to make their motive seem plausible, even if the defense witnesses disagreed.
Makes sense. Plausibility over proof sometimes. Now, what about the weapon? That was always a sticking point.
Huge sticking point. The prosecution had a theory. It was a specific fireplace tool, a blowpoke. It was a gift from Kathleen's sister, Candace.
And crucial,
it was missing. When police first searched the house, no blowpoke.
So the prosecution argues that's the weapon, and he got rid of it.
Exactly. It became this sort of phantom object in the trial. Until...
And the defense pulls off a dramatic reveal.
Yeah, late in the trial, the defense team suddenly produces the missing blowpoke. So they just found it, tucked away in the garage, covered in dust and cobwebs, no blood.
Okay, that sounds like a Perry Mason moment. Surely that torpedoed the prosecution's weapon theory.
You would absolutely think so. Proof the proposed weapon was there all along, unused. But it didn't quite land that way. A juror contacted after the verdict said the jury actually discussed it and decided. The blowpoke wasn't the murder weapon after all. Wait, what? Why not?
They felt the shape and size of it just didn't match the specific type of lacerations on Kathleen's scalp.
So they dismissed the prosecution's specific theory, but still convicted him.
Yeah. They basically concluded he must have used something else. Something heavy, maybe cylindrical, like the blowpoke, but not the blowpoke itself. And that he did dispose of whatever that actual weapon was.
Wow. So the prosecution lost on the specific weapon, but won on the idea of a weapon being used and discarded.
Exactly. The absence of the real weapon still worked against him even after the blowpoke turned up.
Okay, this is already complicated.
Well,
But then the prosecution brings in something from Peterson's past that makes it even darker. We have to talk about Elizabeth Ratliff.
yes. The death in Germany, back in 1985. This became absolutely central to the prosecution's case, arguing a pattern of behavior.
Remind us who Elizabeth Ratliff was again.
She was a close friend of Michael and his first wife, Patricia. She was the mother of Martha and Margaret, the two girls the Petersons later adopted after her death.
And the circumstances of her death.
Eerily similar on the surface. She was found dead at the foot of her staircase. Significant head injuries. And Michael Peterson was the last known person to see her alive. He'd stayed late to help put her daughters to bed.
So what did the original investigation in Germany conclude back then?
Well, the investigation was a bit messy, jurisdictional issues between German and U.S. military police. But the official autopsy at the time concluded she died from a brain hemorrhage, an intracerebral hemorrhage.
Okay, like a stroke.
Sort of. They attributed it to a pre-existing condition she had, von Willebrand's disease, which affects blood clotting. The theory was she had this massive, spontaneous bleed in her brain, collapsed, then fell down the stairs. So the fall wasn't the cause of death, the hemorrhage was.
A natural death, essentially, complicated by a fall.
That was the official finding in 1985.
But the Durham prosecutors in 2003 weren't buying it.
Not at all. They did something pretty extraordinary. They went to court in Durham and got an order to exhume Elizabeth Ratliff's body. She was buried in Texas.
Exhumed after almost 20 years, wow.
Exhumed, brought back to North Carolina, and re-autopsied. And guess who did the second autopsy?
Let me guess. Dr. Deborah Radish, the same ME who did Kathleen's autopsy.
Bingo.
And what did Dr. Radish conclude the second time around?
She completely overturned the original findings. Based on her examination of the injuries on the embalmed body, she concluded it wasn't a hemorrhage followed by a fall. She reclassified the cause of death as homicide.
Homicide, after nearly 2 decades, based on a second look at an embalmed body. That's controversial, to say the least.
Highly controversial and legally potent, because it allowed the prosecution to introduce this as prior bad acts evidence under Rule 404B.
Meaning they could argue.
They argued that Ratliff's death, whether Peterson was directly involved or not, gave him the idea. It showed him how you could stage a homicide to look like an accidental fall downstairs. It established a potential pattern, a blueprint.
They didn't actually charge him with Ratliff's murder, did they?
No, never charged. But they didn't need to. Just getting that evidence in front of the jury was incredibly powerful. It shifted the narrative dramatically.
How much impact do you think it had?
Oh, immense. You go from one suspicious death at the bottom of stairs to 2 suspicious deaths at the bottom of stairs, both linked to the same man. It's devastating for the defense.
And didn't the prosecution also bring up conflicting accounts about the scene back in '85?
Yes, that was another layer. The original German police reports apparently noted very little blood, which seemed odd for a major head injury. But at the Peterson trial years later, Ratliff's former nanny testified there was actually a lot of blood. And another witness testified about someone doing extensive cleaning afterwards.
So suggesting maybe the scene was more violent than initially reported, or perhaps even cleaned up, making it look more like the bloody scene in Durham.
Exactly. It added to the suspicion, tied the 2 incidents together visually in the jury's mind. The defense fought tooth and nail to keep the Ratliff evidence out, argued it was ancient history, irrelevant, incredibly prejudicial, but the judge allowed it.
And that decision, the admissibility of the Ratliff death, became a huge point in Peterson's later appeals.
Absolutely. It demonstrates just how much weight the jury must have put on this idea of a pattern. It wasn't just about Kathleen anymore.
Okay, so despite the conflicting experts on blood spatter, despite the questions around the motive, and with the Ratliff death looming large, the jury comes back. October 10th, 2003.
Guilty. Guilty of the first-degree murder of Kathleen Peterson. And the sentence, life in prison, no possibility of parole.
Now, we need to dig into that verdict a bit. Life without parole usually means premeditation, right? Planning.
Correct.
But the prosecution's main theory was this sudden, furious argument, a spur-of-the-moment thing. How did the jury square that circle? A spontaneous act gets a sentence for a planned one.
Yeah, this is probably the most debated legal aspect of the verdict itself. The jury instructions allowed for a very specific definition of premeditation.
How specific?
Essentially, the judge told them premeditation didn't have to mean planning for days or weeks. It could mean forming the intent to kill just moments before the act or even during the act itself.
So even if the fight started suddenly, the conscious decision to keep attacking her until she was dead, that could count as premeditation in that instant.
That's how the jury interpreted it, yes. They found the act itself was premeditated, even if the initial confrontation wasn't planned way in advance. It's a legally permissible definition, but a very fine line, and one the defense certainly challenged.
A fine line indeed.
Yeah.
And meanwhile, Peterson starts the appeals process. But initially, no luck.
Nope. The North Carolina Court of Appeals rejected his appeal in 2006. They acknowledged some minor issues with the search warrant, but said the evidence was generally admitted fairly.
And this state's Supreme Court
Affirmed the Court of Appeals decision in 2007, so his convictions stood, locked in.
And while the criminal appeals are going on, there's action on the civil side, too.
Yes. Kathleen's daughter, Caitlin, had filed a wrongful death lawsuit against Peterson back in October 2002, even before the criminal trial ended.
And that requires a lower standard of proof, right? Preponderance of the evidence, not beyond a reasonable doubt.
Exactly. And that civil suit was eventually settled around 2007-2008. The figure reported was $25 million.
$25 million. Even if it was a settlement, that's a huge public finding of liability against him.
Absolutely. Whether he ever paid much of it is another question, given he was in prison. But the judgment itself, the finding that he was civilly responsible for her death, that hung over him.
So conviction upheld, massive civil judgment. Looks like the end of the road.
Yeah.
But then things get weird.
Things get very weird. While all this is happening, this completely different theory about Kathleen's death starts bubbling up, totally separate from the defense team's main arguments. The owl theory.
The owl theory. Okay, this is the one everyone talks about. Where did it come from?
It was first floated by a neighbor, an attorney named T. Lawrence Pollard, back in late 2003, not long after the conviction.
And his idea was?
His theory was that Kathleen wasn't attacked by Michael inside the house. She was attacked outside the house by a large owl. Specifically, maybe a barred owl.
Attacked by an owl. Seriously.
Seriously. The theory goes, the owl attacks her head, maybe swoops down, gets tangled in her hair, inflicts those specific lacerations with its talons. She manages to stumble inside, maybe dazed and bleeding, and then falls down the stairs, hitting her head again.
Okay, that sounds wild.
Yeah.
What was it based on? Just speculation.
Not entirely. This is where it gets interesting forensically. Pollard was looking through evidence lists and found something odd, a notation about a feather found at the scene.
A feather? But the investigators initially said there were no feathers, right?
Right. But the SBI evidence list did mention one. So Pollard pushed for a closer look at the evidence collected from Kathleen's body, specifically hair that she was found clutching in her hand.
And what did they find when they looked closer years later?
Microscopic evidence. A tiny downy feather and a sliver of wood, like from a tree limb, both tangled in that clump of hair that had been pulled out by the roots.
Pulled out by the roots? Suggesting a struggle or grabbing something?
Exactly, like grabbing at an attacker or maybe grabbing a branch as she fell after being attacked outside. A later re-examination in 2008 found another microscopic feather fragment.
Okay, that's specific. Microscopic but specific. How did the prosecution react to this?
They ridiculed it. Dr. Radish, the ME, flatly dismissed it, said there's no way an owl's talons could cause wounds that deep, those 7 distinct lacerations.
But Pollard and the theory's supporters gathered experts who disagreed, didn't they?
They did. Around 2010, they got affidavits from several experts who hadn't been involved before, a neurosurgeon, a veterinary professor specializing in bird anatomy, a director of a raptor center.
And what did these experts say?
They argued the wounds were consistent with an owl attack. They pointed out the lacerations were deep, sharp cuts, almost surgical, not the tearing or crushing you might expect from a blunt object.
More like punctures and tears from talons.
Exactly. They argued that talons are incredibly sharp and powerful, designed to pierce and rip, and could potentially inflict those kinds of wounds without causing underlying skull fractures because they don't have the massive blunt force impact of, say, a pipe or a heavy object.
So a scientifically plausible, if extremely unlikely, alternative explanation for the injuries.
Plausible enough for experts to put their names to it, it remains this fascinating, bizarre sidebar to the case. It was never formally presented as a defense in court, but it gained a lot of public traction.
It hasn't gone away entirely, right? It's still discussed.
Still discussed. There was even a book in 2023 by Pollard pushing the theory again, suggesting the attack might have continued briefly inside the house. It just adds another layer of what if to this whole thing.
Okay, so we've got the conviction, the failed appeals, the civil suit, the owl theory. But the real earthquake that shifted everything came from inside the system itself, the SBI scandal.
This is the moment the ground completely shifted under the prosecution's case. It started with broader criticisms of the North Carolina State Bureau of Investigation, the SBI. Attorney General Roy Cooper launched a major investigation into their practices.
And this investigation uncovered serious problems.
Serious is an understatement. It was a bombshell. It led directly to the suspension and then the firing in January 2011 of a key SBI analyst, Duane Deaver.
Duane Deaver, the bloodstain expert from the Peterson trial, the one whose testimony was so crucial for the prosecution.
The very same one. The audit found systemic issues at the SBI, but Deaver became the poster child for the problems.
What exactly did the audit find Deaver had done wrong? Was it just sloppy work?
Oh, it was far worse than sloppy. The audit revealed Deaver had misrepresented evidence, sometimes outright fabricated results, or withheld findings that didn't help the prosecution in at least 34 different cases.
34 cases, that's staggering.
It's shocking. And it had real-world consequences beyond Peterson. There was the case of Greg Taylor.
Right, you mentioned him.
Taylor spent 17 years in prison for a murder he didn't commit, largely based on Deaver's misleading testimony about blood evidence that wasn't even blood. He was later fully exonerated. So this wasn't just about cutting corners. This was about potentially sending innocent people to prison based on lies.
So with that backdrop, how did Deaver's specific testimony in the Peterson trial look under this new scrutiny?
It looked like deliberate deception. Remember, in 2003, he testified he was the seasoned expert. He claimed he'd worked on 500 blood stain cases, testified as an expert 60 times.
Giving the jury the impression of vast experience.
Exactly. But the retrial hearing, using the SBI's own internal records, painted a totally different picture.
What did the actual numbers show?
SBI Assistant Director Eric Hooks testified Deaver hadn't worked 500 cases. He'd written only 47 blood stain reports in his entire career.
47 versus 500. That's not even close.
Not even remotely. And the 60 times he claimed he testified as an expert. Another SBI official testified Deaver had only testified in maybe 4 cases prior, and the Peterson trial was only his 3rd time testifying as a bloodstain expert. Even his claimed mentor, David Spittle, testified he couldn't recall mentoring him in bloodstain analysis.
So his entire persona on the stand, his claimed expertise, it was essentially fabricated.
Deliberately false and materially misleading. That was the finding.
And this led directly to Judge Hudson revisiting the conviction.
It did. On December 16, 2011, Judge Hudson ruled that Deaver's false testimony about his experience and the blood evidence itself had so tainted the original trial that Peterson's conviction couldn't stand. He ordered a new trial.
A new trial. After Peterson had already served, 8 years?
8 years in prison. Hudson's ruling was a scathing indictment of Deaver's conduct and the prosecution's reliance on him. Peterson was released on $300,000 bail, put under house arrest with an ankle monitor.
The legal implications must have been huge for the prosecution if their star forensic witness was discredited.
It gutted their case. A former NC Attorney General even suggested that potentially all evidence collected after Deaver arrived on the scene back in 2001 might now be inadmissible in a new trial because his presence tainted the investigation from that point forward.
So no reliable blood evidence, maybe no evidence collected after the first few hours. What were they left with?
They were left with a very weak circumstantial case. The contested motive, the controversial Ratliff evidence, the autopsy findings that the defense had experts ready to challenge again. But without Deaver's expert interpretation of the blood, linking it all together. It was an incredibly difficult position for the district attorney's office.
Facing years more of expensive, high-profile litigation with a severely damaged case.
Exactly. Which sets the stage for how this whole saga finally ended. Not with another trial, but with a plea deal.
February 24, 2017. Peterson enters an Alford plea. Now, we need to make sure people understand what this means. It's not a guilty plea, right?
Correct. It's a very specific type of plea named after a Supreme Court case, North Carolina v. Alford. Critically, the defendant does not admit guilt. In fact, they are allowed to maintain their innocence.
So Peterson continued to say, "I did not kill Kathleen."
Yes. While doing that, he acknowledges that the prosecution does have enough evidence that if presented to a jury, there's a significant likelihood they could find him guilty beyond a reasonable doubt.
It's like saying, "I didn't do it, but I recognize you could probably convince a jury I did, and I don't want to risk another trial and potentially life in prison again."
That's a pretty good way to put it. It's a strategic calculation. Given the risks, the time already served, the uncertainties of another trial, even with the weakened evidence, this offered a way out. He pleaded Alford to the reduced charge of voluntary manslaughter.
And the sentence for that?
The maximum was 86 months. But here's the key. Peterson had already served 98.5 months in prison before his conviction was overturned.
So, more time than the maximum sentence for the charge he was pleading to.
Exactly. He was given credit for time served, which exceeded the sentence. So he walked out of the courtroom a free man that day. The criminal case, after 16 long years, was finally over.
And this entire roller coaster played out very publicly, didn't it? Largely because of that documentary.
Oh, absolutely. The French documentary series The Staircase, or Soupçon, as it was known in France, was huge. Jean-Xavier Lestrade, the director, got incredible access. He started filming almost immediately after Peterson's arrest in 2001.
Right. They followed the defense team preparing for the first trial.
Unprecedented access. They filmed over 600 hours of footage just embedded with the defense lawyers, with Peterson, with the family. It gave this incredibly intimate, though obviously defense-focused view of the whole process.
And they didn't stop there, did they? They came back.
They did. When the Dever scandal broke and Peterson got the chance for a new trial, Lestrade came back and filmed a sequel, The Staircase Thustant. The Last Chance, released in 2012, covering that whole retrial motion. And then they filmed the final resolution with the Alford plea, too. The whole series spans the entire 16 years.
It's probably how most people know this case. It also gave some insight into the original jury, right?
Yes, interviews with jurors after the 2003 conviction revealed what really swayed them. And overwhelmingly, it was the visual horror of the scene.
The sheer amount of blood.
The amount of blood and those 7 lacerations. That physical evidence just seemed overwhelming, regardless of the technical arguments about spatter patterns or lack of skull fractures.
Even though Henry Lee had made those arguments quite dramatically, I remember hearing he even drank ketchup in court.
He did. Apparently, he tried to demonstrate how blood could be expelled or coughed, creating certain patterns by spitting ketchup. Classic Henry Lee courtroom theatrics.
But it wasn't enough to overcome the visual impact for that first jury.
Apparently not. And that imagery, the bloody staircase, Peterson himself, the family drama, the weird theories, it's just become embedded in true crime culture.
Yeah, countless TV shows, Dateline, Forensic Files, and then the big HBO Max drama series with Colin Firth as Peterson.
Right. And Peterson himself has contributed to the media legacy, writing his own books about it, Behind the Staircase and Beyond the Staircase, telling his side of the story from prison and afterwards.
So if we try to pull back and look at the big picture here, what are the main takeaways from this whole saga?
Well, first you see this narrative arc. Family tragedy spirals into a murder conviction based largely on circumstantial motive and critically forensic testimony that turned out to be flawed, even false. Then this dramatic reversal, not because new evidence proved innocence, but because of prosecutorial misconduct, the reliance on Dever.
Right, a system failure.
And finally, this resolution via the Alford plea, which is legally conclusive but leaves that question of guilt or innocence fundamentally unanswered in the eyes of the law.
It really highlights the power of forensic experts in court, doesn't it? Dever's testimony basically secured the conviction.
It did. But it also shows the immense fragility of that system. When the expert is revealed to be misleading or outright dishonest, the whole foundation crumbles. It makes you question everything.
And it's a masterclass in perspective, isn't it? The prosecution sees a calculating killer. The defense sees a grieving husband wrongly accused. The documentary shows something complex and maybe unknowable.
Exactly. The truth seems to shift depending on who's telling the story and what evidence they emphasize.
Which brings us back, inevitably, to the strangest loose end of all. The owl theory.
Ah, yes, the owl.
Those microscopic feathers, the talon-like wounds. It was never really tested in court as a primary defense, was it?
No, the defense focused on the accidental fall theory mainly. The owl was always this fringe, almost too weird to believe alternative despite having some scientific backing.
So given everything we now know about the flaws in the state's key evidence, Deaver's blood spatter analysis, it leaves us with a really interesting question for you, the listener, to think about.
Right. How should the justice system handle something like the owl theory? It's completely bizarre, totally out there. But what if it's backed by some credible science, even microscopic evidence?
Especially when the prosecution's scientific evidence turned out to be unreliable. What would it actually take for a court, or even just public opinion, to seriously consider the possibility that Kathleen Peterson's death wasn't a fall, wasn't a murder by her husband, but was, well, one of the most freakishly unusual animal attacks imaginable?
Could the system ever accept such an outlandish explanation, even if traces of evidence support it? It's a fascinating thought about the limits of belief and proof in the face of the truly strange.
Something to definitely keep mulling over. Thank you for joining us for this deep dive.